We're live.
All right, this is it. This is cool. I'm so used to just Zoom, and so having all these extra features and it looking this good it's a new experience. I like it.
How did you get a haircut recently?
Oh, yesterday.
Yeah,
it's
no,
not every day. It's not every day we jump on a webinar with 100 people at least. So on those days you got to look good. Every other day, work from home, so we can keep a little bit of a scruff.
Got it. I live an eternal scruff. I can't not scruff, but backwards hat hides all of it.
It's the look, yeah.
So
well, welcome,
this is
man.
really exciting. Yeah, we're doing it. Yeah, thank you. Please.
Yeah, thanks for coming. So I know we'll give it a few more minutes here and to let people kind of trickle in a little bit. But right now, you said you're at a gym, right?
I'm outside Ab Fitness.
How is the gym situation in Brazil? And we'll get into a little bit of the Brazil piece a little later. But
yeah, we can. In Brazil, it's wonderful. This is this is like the smoothie bar outside. We wear a mask inside, and there's no limit on occupancy. And I work out with my trainer, Wanderson. His name is Wanderson, W-A. It's like Anderson with a W first, which was so trippy at the start. But but the gym situation here is amazing. It's wonderful.
Well, it's good to hear. I mean, I know from state to state, at least in the U.S., it's a little bit different. And then beyond that, country to country, we don't have our ears as glued to the ground in other countries. So it's always good to kind of get a perspective on how gyms in other countries are performing, the health of the business, the health of the gym industry in each of those countries. I think it's good to bring that context because I know at the end of the day, we're all, as gym owners, focused on the same things. We want to help our community and to try to do that without as the least amount of restrictions as possible so we can be the most effective.
Yeah, as in Brazil, just so the context is very clear, I'm simply a patron. So I go to the gym as a client. I don't know anything about what their financials look like. But as a lawyer who works with gym owners, all of my clients are in the United States or in Canada.
Okay.
So I have a lot more understanding of legally, from the business end and from the legal end, what's happening there. Whereas here, I just train with Wanderson in 5 times a week.
Solid, man. Well, cool. It's been a few minutes here, so I think we can get rolling on this. So for those of you guys on the call, thanks for joining us today. My name is James. I am the head of marketing here at PushPress. I've been with the company for about 5 years now. I've also owned a gym for about 3 years in Chicago, and I've held every position, I think, in fitness. From personal training to group class to a GM and then finally an owner. And so it was just a natural progression for me to work at PushPress and help as many of my fellow gym owners as possible. And so that's kind of really the concept behind bringing in guests like Cory in front of our community, because what we want to do is bring the resources right to the gym owner. So we can help as best we can. And no, every situation is different. So the best we can do is bring the resources and let's talk about it. So with that, we have Cory Sterling. So I met Cory, I want to say about 6 months ago, and we were just exchanging content. I think it was via email. Actually, no, it was like a DM. People do that these days. You slide into Instagram DM because the content is so solid. And just the way that you guys present your value and your information, and that you focus on the gym owner or the studio owner, it really resonated with us. And so that was what was really important, and I think allowed us to have confidence in us working together. And so just a little bit of backstory. Cory is a lawyer. So when we say, we'll jump on a webinar and a Q&A asking legal questions, we're not doing that with just a bunch of gym owners, talking smack back and forth. But Cory has a lot of experience in the legal space, but then specifically he works with a lot of studios and gyms and fitness facilities. So with that, Cory, welcome, man.
Thanks, James. Thanks for having me. And yes, I am a lawyer. Just so everyone, we're having a legal chat. I am a lawyer, and it's cool. It's awesome to build community around like-minded professionals who have the same mission and the same core at heart. Where that's about building community, helping keeping people healthy, doing awesome things, having your own vision, and going forward. And I think it's awesome that you've had every position. You've worked in every position for a gym. I've done group fitness, and I've gone as an attendee. But a cool thing about the law firm that I started, Conscious Counsel, I started it about 4 years ago, and probably like the first year I would just go visit gyms all the time and just ask questions like, hey, do you have a waiver of liability? Or is your team contractors, or are they employees? And what do your membership agreements look like? And it's a super passion of mine. I love fitness. I love exercise. I love the gym. So being able to build a client base around gym owners has been something really special that I'm really appreciative for.
Yeah, I feel like a lot of the reasons why you got into what you're doing now is really why PushPress is in business as well. It's really to help progress the fitness industry, and specifically from the gym owner and the business owner standpoint.
Yeah, let's do it. Let's professionalize. I know that this particular area, look, a lot of my clients run gyms, and what they're awesome at is running gyms. And typically they're awesome at having a vision, and they love working out with their clients. Or creating programs for their clients or servicing their clients. But a lot of the pieces that don't always come with that naturally are things like numbers, which is why you need to have an awesome accountant, or an understanding of the law, which is why you need to have a lawyer that you connect with and who understands your industry and what you're going through. So I'm here. Let's professionalize it, baby. Let's make it easy. Let's make it fun. I'm all for it.
Well, let's do it. So speaking from a former gym owner, my specialty was absolutely not in my legal structure and any of that, and my head was always as far away from that conversation as possible, just because it's so daunting, right? And so, from your perspective, I guess what are some of the big basics that we should be considering as gym owners right now? Considering that there's still some states that are in restrictions, there's a very fluid policy from city to city, state to state, in the country as a whole. So can you kind of walk us through some of the basics that we should be, considering, and then maybe talking to our own lawyer about?
Yeah, I'm happy to do that. I'm also going to share, if everyone checks this out, we've got a Conscious Counsel. We've made a legal checklist that we can provide to everyone. So I've just shared it with the whole group. And so basically the reason why we came up with our fitness legal checklist is sort of like as the big picture perspective of everything that you're asking about, James. The most common thing that we'll hear from our clients are like, well, I don't know what I don't know, so where do I get started? Or, I want to be at best legal practices, what do I do? This checklist is going to be like your map, it's your guide, it's what you're going to refer to understand what you need. What I can't speak about in whether or not you're open or you're closed or you're reopening. And the reason why I say that doesn't really matter is because at Conscious, in working with hundreds of gym owners all across North America for the past year and a half, we've worked with businesses at every stage. So it's like wherever you are, if you just reopened, but then you just had to shut down, or you're only online, whatever it is, we know what you're going through. And I'll say what I think the fundamental piece, the most important piece to have in place properly is a good waiver of liability, a really strong waiver of liability. So I'll explain a little bit about what a waiver is and how it works, but also the importance of why it's important to have one that is really, really well drafted for you and your business and for your gym. So let's say no one signs anything, right? Which maybe is the position that you're in. No one signs anything. Someone comes into your gym, whether it's a member, whether it's someone on a trial, whether it's someone who's just stopping in for one time. You have a responsibility at law to make sure that that person's going to be safe working out at your gym. And that a law that's called a duty of care. So someone comes into your space, automatically you have a responsibility to make sure that they're going to be safe and that they don't get hurt. Thumbs up if that makes sense, James.
Absolutely.
Cool. We got a thumbs up. So the law says, okay, if that person gets hurt or suffers damages while they're at your facility, you're going to be legally responsible. But there is a legal document that you can get someone to sign, which will release you from liability, which means that you won't be responsible if they get hurt. And it also relinquishes that person's ability to sue you in the event that they do get hurt. So it's basically someone forfeiting a legal right. So the right normally exists unless you sign the piece of paper. If you sign the piece of paper, then the right is extinguished and no one is able to sue you based on that. So I wrote this book. Sorry, any questions?
So I've never been in a position, fortunately, where I've had to fall back onto signed waivers, to fulfill on some kind of any liability that was put on us. But I've always heard that these waivers for our gyms, how enforceable are they?
They are, if they're drafted properly, they're 100% enforceable. Okay. So I wrote this book called the Yoga Law Book, because when I started my legal practice, I was like super into yoga. And so I wrote a book called the Yoga Law Book. And one of the most constant things I would hear from my clients and friends who were yoga studio owners would be like, oh, well, like, we don't need a waiver because it doesn't really count anyways, which is like similar to what your question is, James. And so then I wrote this book and I was doing all of this research, and I did all of these researches about waiver of liabilities. When would it work? When would it not work? And it always comes down to the same principle. Because this whole idea is that someone is forfeiting their legal right, the threshold that the courts will hold is very, very high before they will let someone sign away their legal rights. But if a document is properly drafted, it will apply. So most of the issues that will come up will be with a document not being drafted properly and not covering the specifics of what a business was doing, right?
So that's key, is it's got to be drafted properly. There's a lot of chatter, in Facebook groups and forums and whatnot, where people are asking for templates of waivers.
Yeah.
And so I guess that's where that question came from is, if we have these templates that are floating around, is that the right move?
No, James, it's not the right move. I'll explain to you a couple of principles, but the first thing that I would say is like a templated waiver that you get from your cousin or that you take from someone else's website. It's like going hiking to Everest Base Camp with someone else's shoes, right? And like,
that makes sense.
I went hiking at Everest Base Camp, and like you're walking nonstop for 14 days. It's freezing cold. It's super difficult. You can't breathe. And like the fundamental piece for all of that is that your shoes fit, and then you have shoes that fit you to protect you as you're walking. In the same way that someone could use a template waiver, you could just be like, oh, well, I'm just going to borrow my cousin's shoes and now I'm going to go walking on this crazy trek. But like, if they're 2 sizes too small, you're not going to make it anywhere. And the other sort of analogy I'll always give about waivers, it's like a template is like a seatbelt that doesn't work. You don't need a seatbelt until you need it, right? So like, let's say my seatbelt's broken and I'm driving around for years and nothing happens. Cool, awesome, you can choose to do what you want. But if there's that moment of impact where you need it to help you, you're going to want it to secure you and obviously be able to save your life, or in this case, save your assets and your business. So, and I'll just explain a little bit about why it wouldn't work. The most important, what it always comes down to is how clearly you have demonstrated the activities and the risks that people are going to be going through at your facility, right? So if let's say you have a fitness, we own a gym, and let's say you have some spinning bikes, right? And maybe there are spinning classes that you offer on the side, or people can just use it to warm up, or like one of those. Do you know the name for the fan bike, James?
The Airdyne or the Assault bike. It's
I want to cry.
It's in our community, which is mostly CrossFit gyms, or strength and conditioning gyms. That's a torture tool.
Yeah, it makes me want to cry, whatever that thing is. So if we're talking about your box, if you don't, let's say you have a piece of equipment that's like outside the normal standard CrossFit stuff, and you don't mention it, and someone gets hurt using that, if they get really hurt and they wanna hire a lawyer, I want to see your dog, by the way.
When he's done barking, I'll bring him over.
Okay, cool. Bring him over. So I'll just keep explaining. So the important thing is that the waiver has to cover the activities and the risks. And included in the activities is what equipment that you use. So this is how it happens if someone gets injured. Someone gets injured and now they're having concussion syndromes, or they're unable to work, they can't be on their feet, whatever it is, they're accumulating all of these damages and losses by the injury that they sustained at your gym or your CrossFit gym. And they're going to say, well, it's really the responsibility of the gym and it's their fault that I got hurt. If they're going to then either write you an email personally, or they're going to hire a lawyer who will work off of a commission base to say, hey, it's your fault and this is why you owe us, $27,000 for all the medical appointments I've had to go to, and blah, 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 and all of these things, and how my damage of, my quality of life has changed. If in that, like, let's just use the example of the aerodynamic torture tool that is just, let's say that's not included and that's where someone got hurt. Like the handle slipped off and way crazier things have happened, and the handle slipped and they hit their head and they got a gash and now they're having PTSD or whatever they're going to allege, whatever the situation is. If the waiver didn't mention anything about using, bicycles or using bicycles with fans or whatever it is, this is what the argument would be. And I'll tell you, because I'm a lawyer and I've drafted these arguments before. You're going to say, yes, my client did sign a waiver of liability. They agreed to release you of liability, but only for the activities that you included on the waiver. And there's nothing around using bicycles or this type of bicycle. Therefore, they could not have properly signed away their legal rights. This does not fall under the activities, and therefore the waiver does not stand. My client did not relinquish their rights, and we're going to sue you. And that's what it looks like. Does that make sense?
Yeah, I think that's a really important concept that I don't think resonates with, or that isn't. It's not top of mind for a lot of gym owners. As a gym owner, I always wanted to provide new things, new exciting things to kind of add variation and excitement to our offering. So it would be new equipment every so often, or we might go take a workout to the park, or to a beach, or something offsite. So what you're saying is, if we start to include or expand either our offering or our equipment, then we need to make sure that our waivers are properly updated as well.
Yes, and this is like, okay, and I haven't even mentioned the C word yet, which we'll get to in a second. But like, if we just use the example of the beach or going outside or going to the park, if someone steps on glass there or gets injured or trips over a root or something like that, and that hasn't been included in the waiver of liability, that's not covered. You're not protected by that. So that's why, like, the waivers that we have now, we call them master waivers because they deal with all of these different areas. Now let's talk about COVID. So obviously, if you're facilitating an activity in a space with a communicable disease going around, and someone alleges that they caught this disease or that you were negligent in some way or you didn't follow the appropriate rules while at the facility, you're going to be responsible. So now it's like all the COVID has just like leveled up the need for the waiver and how you use it, but also online workouts have as well, especially for like CrossFit type activities, right? So the way that you just always want to think is, what are the activities? What are the risks? What are the outcomes? And how sufficiently can we capture that? So an example of home workouts or evergreen materials that I see so many of my clients moving to now, it's like the risk now is, people are using their own equipment, they're not being monitored, and we're not able to make sure that the space that they're working out in is safe or not. And so those are the things that as a gym owner, you'd never think like, oh, my waiver of liability should really cover these things. But for me as a fitness lawyer, I'm like, that is absolutely essential.
Yeah, that's eye-opening, I think, especially because gyms and studios have had to be a lot more resourceful about how to stay in business. So yeah, you're right. Everyone's going, or a lot of facilities have been offering some kind of online offering or, personal training services or, personal programming type stuff. So it's good to understand how the waiver should encompass those things as we start to expand our business services. Because nowadays I think we're at a turning point where fitness is everywhere and people are willing to consume it in different places at the same time. So meaning, they come to my facility, pre-COVID, love it. They trust my coaching, but because of, COVID, we had to shut down or restrict our, our capacity. And so then we would provide some kind of online resource or online assistance with them. All the while, I wouldn't think to have updated my waiver for those purposes.
Yeah, that's it. And like, here's just another example. Also, what I have a lot of my clients doing is renting out part of their equipment while they were shut so that clients could work out at home.
That was done too.
That's like, if that equipment is and that's why I drafted a lot of those agreements. So if that equipment is defective, you've given someone a tool or something to work out with. If they suffer damages as a result of that, you would be responsible. And that's why, like, you want to include that in the waiver of liability. If you're renting out the equipment, you want to either take a deposit or, have people sign something once they take the equipment and leave that, like, okay, it's in good standing or whatever. And like, I get it. Look, I speak with enough clients who don't have a crazy amount of enthusiasm for working with the law. That's why I make up for the enthusiasm. I like double down on how much I love all of this stuff. But it's just, I've just seen enough crazy things happen that everything I'm sharing comes from a place of love. And the big thing is I see how hard studio owners have worked. Like in the past year, more than any other year, the hardest they've worked to keep going and to stay in business and to grow and to pivot. And like, just to not take care of a really basic element that needs to be taken care of, to me, it should be prioritized from my perspective and my experiences.
Now, how does this relate to, I guess the restrictions that are being put on and still being worked on, that's again, very fluid. How do those restrictions apply to our business and what we're liable for?
Okay, it matters a lot. And before I answer that, I'm just going to do a poll for everyone who's listening. So this is the question. And James, I want you to make a prediction. The question for the poll is, did you have a protein shake today? I'm going to publish it. James, what do you think the answers are going to be based on for this audience?
That's a yes. That's probably a 75% yes.
75 yes. Okay.
Because I'm willing to bet most who are on this call, they wake up crazy early in the morning. Either they're coaching the first class, or that's when they get their first workout in, or they just get some quiet time before family and kids. And so you have to slam that protein shake first thing in the morning.
Yeah, firstly love protein shakes. I love slamming it.
That's the only way to go down, man.
There's nothing else that's happening. It is a sacred time. And so I'm happy. I can't, as the administrator, I can't vote, but I would be a yes.
It's pretty evenly split.
Yeah. Well, we'll see. We'll give it a little bit more time. So the question that was asked was, how does all of this factor in with opening up and restrictions and what the rules are? And this is what I'll say. Because what we're talking about is something that varies so much from jurisdiction to jurisdiction and municipality to municipality, the most important thing as a gym owner is to make sure you are following the local rules, right? And so the reason why it's important to follow the local rules, there's something at law that's called negligence. And basically what negligence means is like you made a mistake or you fell below the standard of what a reasonable professional would do, right? Let's say something's happening and whatever you're doing, you're offering services that are not in accordance with the rules that are being provided by your municipality or your state. If someone gets injured while you're breaking rules, that's like automatically double trouble negligence. Because, again, this always comes from me being a lawyer and just thinking, okay, if I was hired to challenge this, how would I go about it? And if the first thing I'd look is like, okay, well, what was happening? What were the rules and how were they behaving? So the first thing that you have to do is follow the rules. The second thing that you're going to want to do is make sure that your agreements, as best as possible, explain how your new services operate. And the reason why you're going to want to have something like that in writing, and like, I'll just introduce the idea of a membership agreement and a revised membership agreement, which is something that we've done a lot of these at Conscious Counsel, like in the past 6 months, because people are reopening. There's the procedures that they're operating are different. And so you want to let people know, like, you want to find out what the rules are. And even though the rules can change every 2 months, like, have a separate schedule or appendix to your document that you'd call, like, rules for operation. Hey, we're really excited to reopen at 25% capacity. This is how reservations work. This is how hygiene works. If we have to close immediately, this is what the process is. And like, you want to let people know what they're getting into. In from the various groups that I speak with around the fitness industry, people, it seems more often than not, people are eager to come back. But it's the responsibility of the gym owner to let people know exactly what the process is going to be. And because, like, before it'd be like, oh, like, nothing's going to happen. Now it's like, oh, we could have to shut down for 2 weeks tomorrow unexpectedly. So how do we communicate that, and how do we let people know? Does that make sense?
It does. So I can tell you, talking to hundreds of business owners and gym owners who operate more boutique gyms. And when I say boutique, I mean, smaller capacity, higher touch, higher price point facilities. Community is a very big thing that we push, and then we also trust and lean on. And so, during COVID, there is also this. Well, let's back it up. Our singular drive and focus as gym owners is not really to make money. I mean, we want to provide a living for our family, but we all got into this for the sake of improving the lives of our community, right? And so when the restrictions hit, and this is, I'm hearing these stories firsthand directly from gym owners, we're not going to name any names, but they would go against the local, restrictions and local recommendations. Because from our perspective as health professionals, we know that movement and fitness and working out and exercise, it helps to prevent some of this, some of what COVID or even just general illnesses period can bring on. And so that was always the discussion I was hearing kind of between both camps in terms of, we're just going to go against this and stay in business and keep helping our clients the best way we know how. But on the flip side of that, doing so, I'm hearing is you're completely liable. You're opening yourself up to an immense amount of liability if you go down that route, or if you did go down the route and something did happen.
Yeah, and James, so I'm going to share a story with you of something I went through with one of my clients. I was hired by a gym who I'd worked with them quite a bit before COVID happened. And then they were extremely adamant that they were going to stay open. They're like, okay, we don't care. And this is the example that they used was they were looking at a piece of legislation for the Mental Health and Disabilities Act, which basically says that if someone is suffering from mental health or disability challenges, at law, they need to have the ability to, see a professional to exercise and whatever the legislation said. So their whole argument was, well, we care about our clients. A lot of our clients are suffering, and we don't really care if we have to stay open illegally or wrongly to do it, but we're going to do it. And like, I did all of this research for them, and at the end of the day, they decided to stay open, and they ran the risk of getting daily fines and all of these things. And it's their prerogative to do so, right? As a business owner, in the same way that we do this because we love our community, we have our own vision of what we feel is right and how we want to be leaders for the people who look to us. And so I would never say that it's right or it's wrong to follow the rules. I would say that just make an educated decision with whichever way you go. And legally, yes, you would be more at risk. You're more exposed to liability if you are offering services that are directly in opposition to what a local mandate states.
And that's, I think, at the end of the day, that's what the discussion is around. It's understanding your risk and calculating if it's worth it or not. So yeah, I just wanted to kind of pose that question. I know we do have another question here from Christy. I think this goes back to the waivers. She said some of my clients are in home and in studio. So would she need one waiver for each, or roll it into one single waiver, or does that matter?
Yeah, the way that we've been doing it has been, again, what we call this sort of master waiver, which covers all the modalities and all the ways. So in home, at the park, at studio, online, evergreen content. Like you want the idea is that you want one waiver, which allows you to pivot as need be, so that we know that we're covered. I don't have to think before I do something like, will my waiver cover me? I know that there's 5 options. One's going to be they're accessing recorded materials through my site. Another would be online training. Another would be outdoors. Another would be in studio. Another would be at home. And you just want them to sign one agreement for all of that to make sure, that you're covered.
So there's no effective difference between having one waiver or 5 waivers. It would just be easier to have it under one and make sure everything's drafted accordingly.
Yeah, 5 waivers to me sounds like a nightmare, just because I have so many clients who it takes them a little bit to understand the implementation of one waiver. So the whole idea with the waiver is like, here's this document, sign it once. Unless we change our activities, we don't have to revisit it. And like most people will just sign it, and that's how. And then you're protected. And then
shameless plug for those of you guys who are not PushPress clients, you should be PushPress clients, because we make digital waivers easy to sign and implement. You don't have to do a thing other than make sure your lawyer drafts an updated waiver every time you change offerings or operations. So just
cool.
A plug, and it's free. Just putting it out there.
Yeah, let's do it. That being said, I want to revisit the poll. 68% did not have a protein shake. So not so much slamming, but what I do want to do is I want to ask everyone, what has been the best snack you've had today? And you can throw it in the chat. I've had today. I don't know. I'm a food guy. Like not like a foodie. I'm like a brown rice, spinach, eggs. Let's go. So if 68% of people didn't have protein smoothie, I wanted to see what people are eating.
My snack this morning was, as I was driving the kids to daycare, was almond butter pretzels. Those pretzels where the peanut butter or almond butter stuffed inside. But those are just pockets of calories and pockets of flavor. But you can just sit there and just jam through those, and by the end of the time, you're at the end of the bag and you've consumed like half a tub of almond butter.
Look, there are things that I've heard that are less appealing to me than eating half a jar of almond butter. So far, we've got chips, black coffee, a Built Bar, coffee, and blueberries. So
coffee is an essential.
Yeah, no coffee. I'm a yerba mate guy. I'm going to put my answer in the chat as well. Yerba mate is my go-to.
One thing that my team knows of me now is I've given up caffeine for the past month. And I'm a big coffee guy, so I've been switching over to decaf and a lot more teas. But so far, no noticeable difference in energy through the day. So I think we can kick the caffeine curb, and I just feel cleaner, I guess.
Cool, James. I'm proud of you. Shameless plug. I'm proud of you.
That was a big hurdle. I applaud my team for struggling through that with me for the first 3 days and putting up with me, because those first 3 days, if you're going off a caffeine withdrawal, that's no joke. If anyone's ever done that, you feel sluggish. Your head hurts. I mean, I don't know what it feels like to be an addict, but I guess if I was a caffeine addict and I came off, that's exactly what it was. So it was just eye-opening, and it was a struggle. But we're here. I think we're better for it.
Way to go, dude. Can I quickly talk about trademarks? Firstly, just so everyone who's listening, if anyone has any questions, just throw them in the chat. This is the opportunity. my clients are gym owners, your gym owners. If you have any questions for anything that you are wondering, let me know. I wanted to chat a little bit about trademarks, and then otherwise I'm open to answering any other questions. Cool. So this is what's been coming up a lot for me lately in my business. I will chat about Natalia. I will chat about vaccinations. I'll do trademarks quickly, and then I'll make sure that we get to vaccinations. So the way that it works with trademarks, and this is just something that, like, in terms of legal blind spots, I see a lot of gym owners not being aware of this and not knowing the issue. So usually they're coming to me in a reactive state when the problem has already taken place. The way that it works with trademarks, and the reason why trademarks now post-COVID or in the midst of COVID are more important is because it used to be that the amount of eyeballs and the type of eyeballs that would be on our gym would be local, right? Like, I'm in Boise, Idaho, so everyone in Boise knows my gym, and then, you know, some visitors will come in, a couple will come in, maybe 15% are visitors, tourism, but the rest are my core clients, so I don't really have to worry or think about it. Because now every fitness studio is a fitness studio and an online fitness studio, there's more awareness towards your brand and what it is that you've made. So basically what a trademark is the registration of either a logo or a name or an words with a logo for your particular business. And once you register a trademark, you really get two things. One of those is exclusive use. So exclusive use means that for the goods and services that you're offering, which is operating a fitness facility and fitness instruction and all of those things, you are the only one who's allowed to use that particular name. So that's like the big benefit is exclusive use. The other part of it is that you have enforceable rights, which means that, like, at law, you have certain rights that you are allowed to exercise if someone else is using your particular mark illegally. So best case scenario, I've registered, I'll just use the gym where I am. It's called Ab Fitness, right? I've registered Ab Fitness for a trademark. I'm in Boise. I see someone in Raleigh, North Carolina has registered, starts doing all this promotion and Google ads for Ab Fitness. It's creating confusion in the marketplace, whatever's happening. I have the trademark. I send them the letter and they say, we say, hey, we have this registered trademark. You're not allowed to use it any longer. End of story. It's finished. Worst case scenario, and I've been through this twice in the past week with two different clients. You have your existing business. You've been in business for 15 years, however long, whatever it is. And then suddenly you get a letter from someone saying, hey, we've actually registered this trademark. The mark that you're using is being done so illegally. You have 2 weeks to change your name. Otherwise, we're suffering damages to this degree. And then it sucks because if they already have the trademark finally registered, it's very, very difficult to undo that process. So you almost have no solution to create. If their registration is still in the process, you are able to challenge their registration, but it's a long, stressful, and expensive process. So trademark your business if it makes sense. I hope. Does that come across, James?
I don't see as much on the logo side per se. But I know, again, with a lot of gyms starting to offer, workout programming, any kind of online resources, are those covered within this trademark? Like, say, if I publish a workout program, and then I can see, line for line, movement for movement, rep for rep, that someone else has taken my program that I wrote, and then are selling it off as their own. Does that apply under this, or would I have to look for another solution to cover my material?
So that's for an artistic work or something that's written, or videos that you create, or photos that you take, or music that you make. All of that falls under copyright and not for trademark. Trademark is, and I agree with you, I would say 85% of the trademarks that we register at Conscious Counsel are word marks, which means the name of a business. So push-pull, right? Push-pull fitness, trademark. If you don't trademark it, someone else can trademark it and then force you to stop using it, right? When it comes to copyright's a little bit murkier and trickier, but you can register written works to get a copyright certificate, and then you can enforce those rights if you see that someone has copied something that you've written. Does that help?
Yeah, it does. Yeah, I think there's a little more to explore there in terms of, as you know, workouts published daily or published weekly. So then how does that copyright on that material, if this is kind of a constantly evolving, book of work, how is that covered? Is that covered, or is that even something that you can cover?
Yeah, so the way that copyright works is that automatically after you write something, and like the moment that you hit publish, or if you write it in your journal, it doesn't even need to necessarily be public, you have copyright in what's created. The challenge is, in a practical sense, how do you assert those rights, right? So like it's difficult on an ongoing basis. If I've got a weekly blog about the importance of of a push-only fitness regimen, that would be, and I do that every week, I share the information. That's challenging, but like it's on the website and I could show the date that I uploaded it or something like that. But protection of written materials is a little bit trickier with copyright, but trademark is like super black and white, which is why, because it's the more practical solution, but it also services a different need.
Okay.
So I'm going to answer a couple of questions. Ian says, how do we register copyright? You can go to, if you're in the United States, you'd go to uspto.gov. I'll put that in there for you. And registering a copyright is actually like really, really straightforward and simple. To answer Valerie, if you're in the United States, you'd want to register a trademark through the same website, but like, my experience, I would say probably 30% of the clients who come to me for trademarks tried it on their own first and it didn't work out, because it's a technical, unfriendly, unintuitive process of registering a trademark. And like there's all these necessary searches to do beforehand. So that's something that we offer at our law firm. But the answer to your question is, Valerie, you would go to uspto.gov. If you want to spend a whole bunch of hours looking into it, you can. And then Natalia says, I'm guessing the trademark covers US only. Is that right? If you're registering in the United States, it only covers you there. The way that it works with trademarks is different jurisdictions have treaties together. So while you would, if you want, for example, if you wanted Canada and Europe, if you wanted USA and Europe, or USA and Australia, you would need to register them separately. There's not like a global trademark. All of it's based on the country, but you do have certain benefits afforded to you by registering in, for example, if you register in the US, you have like a blanket, a window period of 6 months where it's as if you've registered in other jurisdictions, but you actually have to register in that particular time. So I hope that's helpful. Cool.
Since I know we have about a little more than 15 minutes left, let's see if we can jump into the conversation around, I guess, vaccinations, and back to Natalia's earlier question.
Yeah. So the legal issue around vaccinations, what we see is that there are a lot of our clients who run fitness studios who want to be able to either only allow instructors to work there who have been vaccinated, or only allow participants who have been vaccinated. So there's a big legal question about, like, is this something that we are able to do? So the first thing to know is, like, the vaccination question is not a question of discrimination or not, which is like, I feel like intuitively most people think like, oh, well, it's discriminatory if you're not allowing someone to access your services because they haven't received a vaccination, then you're discriminating against them, so it's a human rights violation. That's actually not correct, because what the vaccination circles around, the underlying core issue, is a general health concern, right? So it's proven, it's known that if someone is vaccinated, they pose less of a health risk to both themselves and other people around them. And like, I'm not commenting on if the vaccinations are right or if they're good or if people should do this. The same way I said that some business owners will choose to stay open illegally, and they can do that because it's their decision. When it comes to vaccinations, every business owner's I have no preference. Everyone decides what they're comfortable with. But because because this is a health concern, business owners do have the right to say, if you have not been vaccinated, it's not permissible for you to be participating in services with us. And if you've not been vaccinated, then we will not allow you to teach in front of our classes. And it was a little bit shocking to me when, me and my team did a lot of research around this. And someone on the team, Madeline, came up with this whole this parallel with not wearing shoes at a restaurant. James, have you ever not worn shoes? Have you ever been barefoot at a restaurant?
Only in Brazil, man. That's
it, dude. You know how we roll down here. But it's the same concept around. You can't go into a restaurant without shoes or without a shirt because it's a public health violation, and objectively it has health risks that it will pose to other people who are there. And we just vaccinations is sort of the same. I wrote an article about this, and I think I wanted to call it "No shoes, no shirt, no shot, no service," but I don't, it's a sensitive issue, so I didn't move ahead with it. Yeah, no, it is. It's you're not going to get better than that with vaccination stuff. But that's the way that we want to look at it. So the one thing that we just let people know is there's a very big difference between having that rule and then requesting information that you collect from whether or not someone's been vaccinated, i.e. if it's a vaccination passport or if you're taking a photocopy of proof. You want to be really, really extremely careful about that, because once you are collecting personal health information from people, you open up a Pandora's box of legal requirements that you have to follow. So you want to be really careful about that.
So how do you untangle that? For the camp that, would like to, request, vaccination proof from their employees and whatnot, you just take them at their word, and then do you have them sign something?
Yeah, well, basically, this is part of what we've been doing in updating employment agreements or contractor agreements or membership agreements, is putting in vaccination provisions where someone affirms and makes a legal promise that they have, in fact, that what they're stating is true. I have been vaccinated, I don't need to collect the information, and that they also accept responsibility in the event that they're making a fraudulent statement. They promise that they will be responsible for any of the outcomes. So then if I'm advertising my facility as being, vaccine safe or whatever it is, and then it ends up being that one of the instructors lied to us and someone suffers damages as a result, that instructor would be personally liable. And for the time being, as everything's changing so quickly, that's sort of the best that we can do.
Okay. So I, as a business owner, would probably go down that route but stay away or be very careful with asking for proof, because at that point, then we're in a different ballgame there.
Yeah. Then you trigger HIPAA, and
right.
It's all of these rules that you have to follow, and you don't want to, and you don't necessarily need to. There's a different way to do it.
That makes sense. Okay. Let's see. Did we have any other questions? We've gotten some good ones so far, but I think we hit. It looks
like we've answered all the questions. So what I'm going to share right now is so I'm gonna include an offer, something that I do whenever I hop on, do webinars with communities of fitness studio owners. I understand that maybe you have a personal question that you wanted to ask, not in the group, or you have something else that you want to know, or that you're sort of ready to invest in legal documents. So I've just published an offer for a free consult call with me. We've only got 10 spots that are available, but feel free to book a time if it seems like you realize that you're behind the gun with the legal stuff. You don't want to go through the problems and the issues and the stresses of potentially getting sued, or you want to recommunicate in your relationships. I'm happy to help, and always love meeting different fitness studio owners from all over and helping out.
Yeah, absolutely, man. It looks like we do have one more question from Eric. So by mandating employees or clients are vaccinated to participate, does the owner assume the liability if something happens, or if, for any medical issues?
I would see that medical issues that come up as a result of vaccination, I would see that as being a very difficult line. You obviously, it's different to say it's different if and this is why like legal posturing is a thing and why it makes sense to work with professionals. There's a difference between someone affirming that they have been vaccinated versus having a mandated policy telling people that you don't want to tell people that they have to get vaccinated. What you want to tell people is that in order to either access the services of the gym or to, lead classes at the gym, they have to be vaccinated. And it's like, it's a nuanced difference, but instead of telling people like, oh, you have to do this, if you don't do this, you can't work with us, versus we are only working with these types of people, then someone gets to make a choice whether or not they're getting the vaccination on their own terms and you're not involved in that process.
I think that clarification around how it's worded is really important.
Yeah, I always say that law and legal documents are like storytelling. And while the big benefit and the first primary intention always is that you're protecting your business, you're protecting your assets, all of this time and all the struggle that you've put in to keep going. You want your legal documents to protect you in all of these different areas, whether it's like a misclassification of contractor and employee, or if it's someone wanting, chargebacks because the gym had to suddenly shut down. Like, I've been through all of it. And the big thing is making sure the documents capture the type of relationships that you want to have, and that everything's written down in writing and done so appropriately so that you're covered.
Awesome, man. So I really appreciate this conversation. You've made the discussion around legal questions in a gym not boring. So I thank you for that. As a gym owner, to go down this path and start asking these questions in a way that relates to me as a gym owner, I think it's important, and I think the way that you go about it, I think, is also it helps the conversation get pushed forward in terms of just making sure that we're covered for all of the risks that we can assume in the near future.
Yeah, and I just put a question to the poll where I said, is law finally fun? So far, it's 100% no. But the point of all of this is like, look, I've been through so many different types of situations with so many different gym owners from a legal perspective that like the message has to come out. We have to start speaking about these things. We have to understand the benefit of trademarking. We have to understand why we need a waiver that actually covers us. And so I'm doing my best. I'm literally outside the gym. Like, I couldn't be any closer than possible. So I understand that it may be a dry subject. It's something that I'm super passionate about. And the same way with push-pull, like, I want to see my clients succeed. I want to see them focused on building their community, focusing their time on, actual training or revenue activities. And so we take care of the legal solutions for them with a lot of love and fun.
Awesome, man. So I think we can start to wrap this up a bit. Do we have anything? I know you offered the consults. Maybe we can put the checklist in there one more time for those who were late to the chat.
Cool. Yeah, I've just shared it again.
Sweet. So well, awesome, man. I know this definitely won't be the last time we do something together, and we'll work to kind of digest some of the information that we've discussed on this call for future resources and content we'll put on the site, on yours as well. But yeah, the more that we can start to bring resources like you in front of our community, I think that only helps. It helps in the success of our clients.
Cool. I'm happy to hear that. I'm excited. I'm really happy I slid into your DMs, James. I'll just say that. And I'm here to help. If anyone has any questions afterwards, you can book a call, and please know that I'd love to help.
Yep, and we'll have some resources around Conscious Counsel on our blog, pushpress.com/blog. You can just search for Conscious Counsel. We'll make sure we have some stuff around them as well, so you can easily get in contact with them, or we'll find that checklist there as well.
Okay, cool. Thanks, everybody. This was a real pleasure, and good luck and keep in touch.
Thanks, Cory. We'll see you.
Ciao.